Well, welcome back to the Law Show. I am Randy Thompson, and I will be your host for this segment of the show. The Law Show is brought to you by the firm of Kerrigan, Estes, Rankin, McLeod, and Thompson. I am Randy Thompson. I'm one of the partners with this firm. I am a board certified civil trial lawyer, and I am proud to be a member of this firm for more than 26, 27 years now. It is a great place to work. And one of the things I like most about this law firm is that each individual partner has different opinions about different subject matters. And so I might talk to you about my opinions on a particular area of the law, and Bob Kerrigan or Mike McLeod might have a completely different opinion about it. But it's one of the things that makes working for this law firm so nice. The doors are always open. I can always go in and speak to Bob Kerrigan or Mike McLeod, Bill Rankin, George Estes, and ask their opinion on a particular item, and it's very helpful. I want to talk a little bit this morning about what it means when you call our law firm and how it plays out. Our firm specializes in personal injury claims that are caused by the fault of someone else. There are a lot of claims we don't handle. We don't do domestic law. We don't do divorce work. We don't do real estate or probate law. We don't do contracts law really, except when it comes to play with your car insurance contract. But because we focus on medical malpractice, product liability claims, what we call premises liability claims, or trip and falls and slip and falls, and we focus on automobile accident claims, because that's what we focus on, our staff knows exactly what we need in order to determine whether we'll be able to help you. So if you were to call our office, for example, about a trip and fall or a slip and fall, I'm the attorney that handles the vast majority of those for this law firm. Because I've handled so many of those cases, tried so many of those cases, mediated so many of those cases, there is certain information that I know is going to be important from the very beginning. So if a person calls our office and wants to talk about an injury from a premises liability claim, we have a person who takes down the basic information at the beginning. And so we want to know what time of day did the accident happen, of course, how it happened, what were the weather conditions, what was anything said during the accident. Did a manager or an associate manager or some property owner come up and speak to you about what happened? Do you have any photographs of the area? What are your injuries? And whether you had any pre-existing injuries. We also want to know, because I want to know, what kind of shoes you were wearing, what kind of clothing you were wearing. And all of that information is taken down by our intake person before I ever get on the phone and return your phone call, so that I have a basic understanding of what your call is about and what your claim is about. And then once I start talking to you, what is very important to me is your demeanor, your manner in speaking to me. I know from my experience that if the caller is telling me, boy, it's a slam dunk case, you can't lose this case, I'm telling you, that's when red flags go up in my mind. Wait a minute now, I'm the lawyer. I'm going to be the one that knows better than you whether the case is a valid claim or certainly a strong or a weak claim. Well, what makes a strong or a weak premises liability claim? In the state of Florida, the injured party has to prove by a preponderance of the evidence that the dangerous condition on the property, and that can be sharp edges on a countertop, poorly stacked merchandise, slips from water on the floor. The injured person has to prove that that dangerous condition was either caused by the property owner or it had existed for a sufficient length of time that the property owner should have known about it, should have discovered it. So, for example, in a case where a client walks into an auto parts store, and as soon as he opens that door, there's a rolled up welcome mat that he trips over. That's a strong claim. You should not have rolled up mats right behind the door where somebody literally, I mean, it's literally one of the best tripping hazards that if they wanted to create on purpose, that they could create. Because as you open that door, you're expecting the pathway to be clear. And in this particular case, it was a cleaning crew who was, I think, changing out the mats, and they had simply rolled them up and left them at the door while they went to get other mats to put down. Other claims are where the client says or the caller says, I don't know. I don't know why I fell. I don't know what caused me to go down. All I know is I was walking and down I went. Well, again, the plaintiff has the burden of proof. The injured party has the burden of proof. And so when the injured party says, I have no idea, well, then how do you overcome that hurdle? It's very difficult. Sometimes there were independent witnesses who said, oh, yes, I saw the manager mopping the floor right before your client came in, and then your client went down hard on her knees. Well, that makes, sense. Sometimes the client is laying on the floor and the manager rushes up or the employee rushes up and apologizes and says, I'm so sorry, that's my fault. I should have put up a warning sign, or I'm the one who placed the packages right there or stacked them that way. I'm sorry. But most times that doesn't happen. And in reality, most times the client gets injured and they're embarrassed and they just want to get up and get out of the store. They don't want people looking at them. They don't want people talking to them. They don't want to make a big scene. They've already embarrassed themselves by falling. And so it's a normal reaction, in my opinion and my experience, that clients and customers are more embarrassed than they are angry or frustrated. But then as the client leaves the store and gets home, and the client realizes, wow, I'm stiff, I'm sore, my back is really hurting, I've got a headache that won't go away. That's when, at that time, then the client oftentimes thinks, well, that was wrong. That should not have happened to me. I want to call a lawyer and talk to a lawyer and see what my rights are. A lot of times I have callers who say, listen, I'm not the litigious type. I'm not the type that wants to sue. But of course, they're calling me because they want to file a claim, or they at least want to know about their claim. Here's what I think about that. I don't know of anyone who is a litigious type. I guess there's some certain high-profile politicians, ex-politicians, who love to file lawsuits, who love to get involved in lawsuits and litigation. Most people aren't that way. Most people would rather go about their life, not get injured in a car accident, not get injured in a trip and fall, slip and fall case, not have unpaid medical bills that they're worried about, not have ongoing injuries. So I think, most people don't want to be involved in a claim or an injury. But sometimes that's your only way of seeking compensation for the real injuries and the real impact of a fall or a car accident. So I think I talked to you earlier about the demeanor of the client when they call and they say, well, by golly, it's a slam dunk case. Be aware of that. Or they're so angry and they're so bitter and they're so fuming mad that they don't listen to reason. They don't hear. And by golly, they want this person put in jail. Or by golly, those are very difficult clients to help, because what I know from my standpoint as a trial lawyer is jurors like people who try to help themselves. Jurors like people who are positive and upbeat, even in the worst case scenarios. So when you have a client who says, I can't do anything anymore, I can't ride, I can't go fishing anymore, I can't get in my car, that sends a message. Now, sometimes that's absolutely true, but that sends a loud, strong message to the jury or to the adjuster. When in reality, what I like to try to get my client to do is talk about the things they are left with, the things that they can still do. Yes, I can still wash my own car, but it takes me 5 hours now because I have to take a break once I do the hood, and then I can move on to the side of the car. Or yes, I can still garden, but I have to get out there in my walker, my rolling walker, and I have to have help getting down on the ground, but I still enjoy trying to be outside, trying to move along. So all of these items, all of these attributes of a person who's been injured and the injury itself, how it happened, why it happened, what the conditions were, all of that plays into, well, is it a strong claim? Is it a valid claim? Do I think I could convince an insurance company that it's a valid claim? Or if not the insurance company, can I convince 6 people sitting on a jury that my client is credible, is being honest, is being realistic about how this accident has impacted them? So those are some of the factors that we deal with as lawyers on a daily basis. We're glad to help you, and we're glad to answer your questions. If you've got a case about an injury that happened through the fault of someone else, I'm glad to talk to you about those. Again, I'm Randy Thompson. I am a board-certified civil trial specialist. I would encourage you to look us up on the web at Kerrigan.com. You will find a lot of information about the lawyers and about our law firm and the type of work that we focus on. We enjoy doing this show on Sundays. We enjoy the feedback we get from neighbors in the community who watch it. So please keep watching. We'll be right back after this break.